Hi, and welcome to the last in this series of videos about Topic 7, capacity in fundamentals of contract law. All of the other videos have really focused their examples on minors or people under the age of 18, but there are a number of other different categories of persons who might fall within the incapacity framework, and we need to understand what's required there. So the most common is people who are intoxicated, drugs and alcohol, or people who are mentally impaired in some ways, whether as a consequence of a mental illness, a brain injury, dementia, or some sort of intellectual disability. Essentially, contracts made with these people are voidable at the option of that person. So similar to contracts made with minors. However, it's a little bit tricky. It's pretty easy to demonstrate that you're under the age of 18. The onus of proof is on the person seeking to avoid the contract as a consequence of the capacity. Of course, that person might be represented by a guardian or a special friend, but nonetheless, there is an onus of proof. So they must demonstrate, if they're seeking to avoid a contract on the grounds of incapacity, that they were incapable at the time that the contract was made of understanding what that contract meant. Secondly, that the other person to the contract knew or ought to have known of the incapacity. So a person who's lacking incapacity might also have the defences of non est factum, so that is, they might be able to avoid the contract as a consequence of mistake, and they may also have an action in relation to unconscionable conduct. Both of these, again, are remedies that you'll discuss in advance contract or possibly also in trusts and estates. Your textbook refers to a case of Lampropoulos, I think it is, Lampropoulos and Kolnick. In that case, the parties entered into a memorandum of understanding that gave the plaintiff, who was an estate agent, an option to purchase a house from an elderly man who was suffering from some sort of impaired cognitive capacity, probably dementia. The court set aside the contract on the grounds that the elderly man concerned lacked the mental capacity at the time, and the plaintiff ought to have known about the man's reduced mental capacity. This knowledge could be inferred from a number of factors, primarily his age, the fact that he was prepared to enter into an agreement to sell his house at a significant undervalue, and from the general disorder of the house. The transaction was also able to be avoided on the grounds of unconscionable conduct. What about bankrupts? So basically, despite what television programs might tell you, a bankrupt does have the capacity to make a contract. However, there are some rules around that. An unprofitable contract that's made prior to bankruptcy can be discharged or disclaimed by the trustee in bankruptcy. Legislation can also restrict the nature of the contracts that a bankrupt person can enter into. So, for example, the extent of the credit that they can obtain. And the legislation also makes entering into some kinds of contract without disclosing the bankruptcy, at least in respect of property, an offence. Contracts entered into a bankrupt after the commencement of the bankruptcy, again in respect of after acquired property, are valid, provided that the person dealing with the bankrupt does so bona fide and for good consideration, and provided that the transaction is completed before the trustee in bankruptcy intervenes. Relevant provisions are Section 269 of the Bankruptcy Act, and that provision prohibits an undischarged bankrupt from obtaining credit, goods or services, or entering into a hire purchase or leasing agreement for an amount over $3,000. So what about government? A common law proceeding shouldn't be taken against the Crown, or could not be. So what about contracts with the government? Does the government have capacity to contract? This has been a vexed issue at common law, and, short answer is no. A government doesn't have capacity to contract. It doesn't have a separate legal identity in that sense. And when you think about it, there are concerns in relation to trading or entering into contracts with government as such. Governments change. That's often referred to as sovereign risk. In Australia, legislation has removed this idea of Crown immunity, this lack of capacity of government, which has largely, in the cases, been a way that the Crown has avoided its responsibility under contracts. There are, however, limitations. The power of the Crown to contract can be limited under statute. The Crown is not permitted to fet a future exercise of its discretionary powers, and we saw this as part of the discussion in the Australian Woolen Mills case. And a parliamentary appropriation is needed to pay the damages. Okay, so what about the bad guys? What about felons? At common law, a person who was sentenced to death, convicted of treason or a felony, was considered to be attainted. They lost all common law rights. So literally, their blood was seen as being corrupted and they forfeited all property to the Crown. Now, you might have thought that that's an idea that had gone away, but I find this case of Dugan in the Mirror newspapers really interesting. So Dugan committed some sort of heinous crime and was convicted to, was basically sentenced to death. Subsequently, his sentence was commuted to a life sentence, and after some 20 years in jail or so, he then was allowed day release, and he committed some offences while he was on day release. The Mirror newspaper wrote about those offences, and Mr. Dugan, who actually had another 14 years added to his life sentence, took offence to those statements that were made about him in the newspaper and sought to exercise his common law rights in defamation to sue the Mirror newspaper. And the Mirror newspaper used the defence that he was, because he had been sentenced to death, he was attainted and he no longer had common law rights. And essentially they could defame their little hearts out. And essentially the court agreed with them there, because he had been sentenced to death, that the common law rule still applied. It's less clear where there's no death sentence, but also it's very difficult to enter into contracts other than possibly those that have an illegality issue attached to them anyway. It's very difficult to contract whilst you're in prison or suffering incarceration. So the issue just doesn't come up very often. So what about married women? This is really an historical anachronism now. At common law, women couldn't, as a general rule, enter into any contract on her own account. That included contracts with her husband or third parties. This has basically been statutorily altered since the end of the 19th century, and it's really only relevant now in the context of the potential for contracts between spouses, where the real question there is intention to enter into a legal relationship. Another historically, well, possibly historically anachronistic category of persons who might be subject to capacity issues are illegal aliens, or enemy aliens in particular. This arose as an issue particularly during the Second World War, the extent to which persons who were incarcerated because of their enemy nationality could enter into contracts. Where that stands at common law, there is the capacity or the ability to determine somebody an enemy alien and remove their common law rights. I think statute would, and also international conventions in relation to human rights would, I hope, have some impact there now. But I think in these troubling times, that's probably something that we need to pay attention to. Okay, now we're in my home territory, corporations. Historically, capacity was given by the existence of the company's constitution, formerly referred to as its Memorandum and Articles of Association. And parties to a contract were taken to be aware of any restrictions in the constitution. Let me step back from that a minute typically or historically, and one of the things that I know you're just going to love when you start to study corporations law or company law is that companies were really formed as a way of separating individual investors from the risks that they took and limiting the liability of the individual investors to their investment in the company itself. And a company took on or takes on legal personality. It has the capacity to sue and be sued in its own name, and that means it also has the capacity to enter into contracts. So the issue is not so much can a company contract, it's whether it's done so properly. So as I started to say before, historically capacity went to the memorandum of articles. So the memorandum in particular would set out, these are the things that this company is for, these are the powers that it has and the things that it can do. And so it might limit that company's capacity to enter into contracts, say, for the purchase of robots. A company might say, we've been formed only for the purchase of robots and for no other purpose, so purchasing something like this telephone receiver, which is not related to the robot, would be ultra vires or outside of that company's capacity. These days, much less drama. Section 124 of the Corporations Act gives the company the same legal capacity as any individual, so it can't be limited by its memorandum and articles. The other thing that is really relevant here is Section 127 of the Corporations Act sets out how a company can execute a contract or a deed. So it sets out the people who have the authority to bind the company, and that's essentially its directors, or those people who have ostensible authority, who the directors have authorised for the purpose of signing the contract. I commend you to have a look at the section and get your head around it. It sort of seems very straightforward because we're dealing with companies all the time, but I think it's a really good exercise to think about it and understand how it works. An issue that comes up with corporations in relation to capacity is what happens when a group of investors haven't yet formed a company, but they're trying to work out whether or not their investment is going to be possible, if their business plan is going to work, and to do that they need to do things like engage lawyers, enter into preliminary agreements, say non-disclosure agreements about their business plans. They want those contracts, ultimately when a company is formed, they want the company to have the benefit of those contracts, and they want it to be the company that is vetted with the obligations under them. The Corporations Act under Section 131 provides for this idea of pre-incorporation contracts. So contracts that are entered into by people in anticipation of forming a company down the track that are subsequently ratified by those companies can bind the company. That's all I want to say about capacity. Do remember that it's not a formation element. It's a question that we need to turn our minds to once we know that all of the other elements of a contract exist. And like formalities, it's only an issue in a very limited set of circumstances. As a key takeaway, remind yourself too that even though certain types of contracts that are entered into by people who lack capacity are void or voidable at the option of that person lacking capacity, we're not talking about void in the usual sense of void ab initio. We're talking about the contract being something that can be avoided by the minor. As always, any questions, comments, frustrations, compliments, ideas? I'd really love to hear from you. You can do that via the discussion board. You can use our Facebook page. You could just get all old-fashioned, give me a call, send me an email, or ask a question in class if you're one of the face-to-face students who comes to class.